Well, the matter was postponed to the 14th of November, mainly because the state had not yet filed its heads of arguments. We filed our heads of arguments long back. Then the state was not ready. What they indicated was that because of the new system, online system, they had not been joined to the case, so they were not aware of the fact that today was the court date. So they need time to be able to prepare and file their heads. So the matter is on the 14th. Then there is also an additional element. You might have heard the exchange between me and the judge, Justice Chikole. We are going to be seeking that he should not sit in the matter. We're making an application. That's what we were saying, that it will be made in open court. The reason that he is the judge who presided over the application by Ngarivhume for bail pending appeal. You would recall that he dismissed that application. And in dismissing the application, he expressed some opinion that he did not think that there were reasonable prospects of success. So obviously we would need another judge because he already has some view. I'm sure that is what will happen on the 14th, first and foremost. That's what they were saying. We would apply in open court. And also they indicated there, if you were following the proceedings, that we would have to avail to the court his judgment in the bail application. Bail pending. That's also, it will be heard on the 14th.
Can you give us some of the arguments that you are making in your application?
Well, in our appeal, we are making very clear arguments. We think that our client has very reasonable prospect that the conviction was wrong. You will recall that the only reason why the magistrate court convicted was that he did not disclose at the time he was questioned by the police that he did not have a Twitter account, or that particular Twitter account was not his Twitter account. That is the sole issue. They said, why did you not say it the first time you were interviewed by the police? Now, we are saying that was wrong. The person is permitted not to say anything to the police when they are questioned. That's first point. And secondly, that in fact when he was questioned, they had not indicated to him what Twitter address was. So it's going to revolve around that very important point. Then secondly, we have said that before, and we said that the magistrate court didn't understand that. If you want to say someone has no Twitter account, you can't speculate. Get the evidence from Twitter. Twitter has a clear process where government agents around the world can investigate and find out whose person's accounts and so on are there. Those are the kind of things. And I think for purposes of our own criminal justice system in the country, we cannot have police officers who would come to court and start speculating, no, he didn't. I mean, we just cannot second guess. If an account is, if someone's account, just let's have a very hard fact of whether it is his account. So their failure to call Twitter or to get evidence from Twitter was very fatal. We expect the High Court to agree with us on that point. So he has excellent chances of success on appeal.